your convictions on it. You know, I don't want to represent you. I mean, you know, you say it obviously in a better fashion, and I don't lie, but I will often say I don't think that I'll be helpful to you. I don't think that I'll be able to represent you in the way that you need to be represented. You know, I mean, and obviously always depends on the circumstances, but that may be an occasion where I don't want to take the representation. I mean, but we're also have plenty of times been in cases where you're in for the whole show and your client does something and then you handle it the same way. You know, it's damage control. However you might need to do that. But that's what I mean about sort of, you know, trying it. Most of us date before we, you know, or check out a car, you know, you hit the tires, whatever that expression is. And that's in some ways what this is. I don't think exclusively, but I think you can use it for that very purpose. There have been programs here and other bar associations on the very fine line between people going through this process, divorce or custody battles, whatever it may be, and mental illness. I mean, sometimes I'm a layperson, I'm just a JD. I don't know. And so sometimes after you've known a client a little longer, you can get a better feel for it. And if you're equipped to handle it. I mean, sometimes your caseload just can't handle. You know, I can only take so many high demand clients at one time.
And I'll often say too, just have a frank conversation, just like you would with any other client. You know, you've made these few court appearances, it hasn't been going well, you know, these are maybe some reasons that I see that you've been struggling. Here's what I would suggest that we do to try and kind of get back on track, and I'm going to have this conversation with opposing counsel. But just to be just super direct like you would with any other client, you know, I never attempt to make any sort of guarantee to a client, but, you know, kind of talk about different potential outcomes and different potential strategies, just like you would with any other client.
To further talk about the whole communication piece, and Cynthia and I did talk yesterday a little bit just to figure out what we should do. Since we weren't attending the training, I don't know exactly what already occurred. I mean, we attended the training originally, but, you know, it's changed over time. But we talked about the communication piece, and sometimes the communication that LAR requires, you know, you probably can't charge for. I don't charge for a lot of it, you know, that real in-depth filling out the engagement letter and the lists and all that stuff. It's an upfront cost, but I think for myself, it's worth it in the long run to really be very clear, because again, people know approximately how much they can expect to pay. They can budget for it, or, you know, give the retainer, the full retainer up front. Again, it always varies. But I think it's helped in my practice, even communicating with my non-LAR clients, because discussing fees, money, that sort of thing, especially when people are saying, oh, you know, I don't have $10,000, you know, I'm gonna, you know, it's a sad story from many people. $10,000 is a lot of money. Most don't just have that in a savings account that they weren't using anyway. So it's personally has helped me be much more direct with potential clients.
And I find too, and I think I put this in my slides, that although the program was developed as an access to justice piece, there's no law that says it must be for low-income folks only. I use a sliding scale, so I have kind of an income sliding scale, and I use it with my flat fees. So, you know, if your income is like under $30,000, you get one flat fee. If it's up to $60,000, you get another flat fee, and if it's over that, you get another flat fee. And I think, again, people identify with that frankness. So they'll call and they'll say, I understand you do low income, I understand you do LAR, and if they're a low income client, and I can say, you know, based on our conversation regarding your income, you can qualify for this. And I think that some of it too is, you know, no lawyer wants to be a salesperson, but at the same time, you're creating a value proposition for your client. And you're kind of making them feel like, oh, you know, I got this, like I qualified, and it kind of makes them feel good. if you're talking to somebody in an initial conversation and you kind of get a sense that, nobody wants to pay their family law attorney. So, nobody is going to tell you, I have all kinds of extra money to pay you. I'm doing great. I'm so excited to write you a check.
You'll get a bonus.
But you get a sense, you kind of have an initial conversation with folks and kind of what their assets are and where they live and whether they own their home. And you think, okay, buddy, like you don't really want to write me a check, but this is what it's going to be. And you kind of say, I would like to offer you, although I do offer low income services, based on our conversation, this is what I would be happy to offer you. And I do, I don't by any means limited my LAR or flat fee work to low income clients. And, for the same reason that the low or limited resource people appreciate it, the folks in the higher income bracket appreciate it too, because, how much is this going to cost? When do I have to pay you? How do I pay you? Those questions still, come from no matter what the income is.
Which, before when I said I bring it up a lot more, I used to bring it up more in the modest income bracket people when they would come to have a consultation. Now I do bring it up to, all sorts of people, income categories. And again, it's more based on their reaction of, do I really want to commit so completely to something like this? And it may be a little frustrating now that you're certified, you'll get on some list at a court. I have, and you should, it's just a list of people who are certified to do LAR. I have gotten a couple of good clients from the list. I do accept reduced fee also. But sometimes people hear limited assistance with either low income or limited something, I don't know, but other than, the events or the types of issues that you're handling. And that can be a little frustrating because, they call you and they say, no, the court said. The court didn't actually say, because the court never actually recommends anybody to, direct you to a list. I think it's happening less and less, and people are thinking outside of it just equating limited assistance with low income. So I'm finding more often than not that I'm charging my usual hourly rate, but in a limited assistance. And so for me, it's, again, even better because I'm getting my regular hourly rate and, it's not toward the end where the money tapers out. Right before pretrial, I was on a pretrial this morning, and I spent hours, in this particular case, it was going to be very important to do a really good pretrial memo. And my client wants a lot of involvement. So that adds, to the cost when it adds to the cost. And so, before you go to court, the 48 hours before you go to court can often be very expensive couple days. So I'm not stuck then, with the retainer that ran out at the four-way, that went on for 6 hours.
Yeah, so I think, you go ahead.
No, I was going to say maybe we should open up to some questions, but I...
Yeah, go ahead.
Just since so many things are interrelated, overlap, and it's sometimes difficult just to handle one particular issue without it overflowing into another issue that you're not supposed to be handling according to the agreement.
Yes, I think it is. I really do. I'd be curious to hear what your reaction is. That's why I tend not to do too many things by issue, unless it's really discrete issues. So most of my LAR is event-based, as opposed to issue-based. And does everybody understand the distinction between those two? It may be that even though I'm representing somebody, say for the pretrial, they are still going to, I don't know, gather reports or witness information. And so I can be very clear in that. But I agree, it's really hard to, prepare child support guidelines without preparing a financial statement. And I think that's a matter of knowing your practice as well. I think it's very difficult to go before a judge and to have not signed a financial statement. You say, well, I'm here on an LAR, it was an issue, I didn't do the financial statement part. I just think it's hard to do. Some people can do it, and I think it depends on the person's finances. Sometimes it's a lot easier to sign a financial statement. I mean, the difference, a financial statement can take you, a half an hour to complete, or it can take you 3 hours, 8 hours. I mean, if you're looking through, you get a client who brings the shoebox of all the bills for the past years. I have no idea what my gas bill is. Should I?
Yeah.
I think it's a really, really difficult, in certain circumstances, to divide issues in the family law context. But keep in mind that it may not be for everybody in the family law context to break it up by issue. This is expanded, it's in the housing court, so it may be a lot easier, I think, although I don't do housing work, to do it in the housing court, because it's let's say, the eviction. Voila, that's what it is. Did you have a particular issue, though, in mind? Yeah.
Yeah, I tend to do event-based. So I'll, for the pretrial conference, for the status hearing, for a specific event. Lately, I've been doing, helping folks. There's kind of a bit of a niche of people, they're reasonably kind of comfortable or confident or a little bit more sophisticated, and they say, I think I can go in and do the hearing by myself, but I don't understand what this financial statement is, and I've heard that it's pretty important. So I've begun doing kind of just helping people with the financial statement, and again, charging based on income, kind of a flat fee just to prepare and review the financial statement. They sign it, it says prepared with assistance of counsel, so we're still kind of following those guidelines. But for those folks who don't necessarily, they're a bit more sophisticated, they think they can handle the hearing, but they're unsure about making sure that they have their child support guidelines, their financial statement in order.
You would sign the financial statement?
No. So
You would file a notice of
No, I help them prepare it just as if it was, any other kind of a pleading or a complaint. I work with the client to review their financial documents. I have conversations with the client to make sure the financial statement's accurate. I say prepared with assistance of counsel without disclosing my name. The client signs it, so the judge understands, okay, the client has some assistance. It was under a limited assistance basis, but the client would go into the hearing there on their own and present that on their own. I'm big on the value proposition. I'm like, how can I get something out of it? Yeah.
How do you deal with discovery since it's an ongoing process when you're only doing a limited hearing?
Sure. So, in the family court, number one, a lot of the discovery is financial. A lot of it is kind of making sure that the financial statement's limited. I have done, depositions on a limited appearance basis, sitting in with my client on a deposition if they're being deposed. And again, making sure that the fee agreement is clear, making sure that I don't sign off on taking any of the costs for the transcript, or if I have, I'm charging a stipend to make sure that that's going to be covered. In terms of interrogatories or requests for production, sometimes clients will come in and, they kind of say, oh my God, I received all this paperwork from this attorney. Can they do that? And you kind of sit down and help them with that. And the same kind of thing where you are not necessarily filing an appearance at the court, but you're signing a fee agreement with the client and a cover letter with the client saying, consultation for this preparation of discovery, and you will be required to gather up these documents. We will review them together. And again, not signing anything, making sure that it does reflect, though, prepared with assistance of counsel.
Same.
Yeah.
I've never done a deposition.
Yeah.
It's just not come up. But in terms of the discovery, the communication between you and your client is really what is most important. But I think making sure that the other attorney understands also. If you're doing discovery and also negotiating, I think there are two parts. Sometimes I'll help somebody prepare discovery requests or even answer discovery requests, but I'm not involved. I've never introduced myself to opposing counsel on this matter. So they don't necessarily know I exist, but most of us can tell if somebody else has had assistance. a lawyer friend or a lawyer that they've actually retained. So I think it varies, but, that whole, prepared with the assistance of counsel, I think is pretty key, because you never know when you are going to come in on the case. And you just don't ever want, let's face it, some judges are very direct, and they very well may ask the client, did somebody help you with this? And I've heard judges, ask names. Not in the LAR situation, but, when you've heard the colloquy at the end of, when they've produced a separation agreement, I have heard judges say, who did you see? And I think testing them sometimes, frankly, did you really see somebody, did somebody really look at this? Does that person have a name? Just to make sure that they're covering all their bases, I imagine, to say whether it's a fair and reasonable agreement, to make sure that it really was with an attorney.
Yeah, and it's just being respectful. It's just all that kind of communicating and just being respectful, of the court, of your colleagues, because it is a fairly small bar. And you do start kind of work with people on a more regular basis, or at least to come into contact with them, and you just want to be kind of on the straight and narrow with people, and I think people appreciate it and respond to it.
But that is another pitfall. So now I'm going to think of all the pitfalls. I say that I'm a big believer in communication, and I am. And I think it's key to a successful LAR practice. But sometimes you just forget, because you are treating these clients as if they were any other client, the same as you would with a low-income client. It doesn't matter. You're still a zealous advocate, et cetera. And so it's important that whatever your tickler system allows for, however you're going to do it, that you do remember to do the new engagement letters or fee agreement, whatever it may be, that you're communicating appropriately. And I find that is particularly the case when you're doing more of a consultation role, as opposed to an actual event, like a court appearance event, because some things can just go on and on. And additionally, when you have a client that is my client today, I've been representing her now for a couple of years. Unfortunately, the parties are somewhat frequent flyers in the court system, I'm sure is how the clerks view them. And she just automatically calls me, and I think that she just always assumes I am her attorney. And so I appreciate that she feels that connection, and whenever, her ex files something yet again, she'll just call me as a matter of course. And I have to remember to stop and sit back and say, okay, we need to go through that again. It shouldn't be that big a deal. We have computers, you do a save as, you change the circumstances a little bit, change the date. It should be just as good.
Yeah.
Can you give some examples of things you might know in connection with a mediation?
Being a mediator?
No, I thought more in terms of if people have gone through mediation, do they ever want you to review it or get involved or?
Yes, but I don't see that as an LAR moment. Because when somebody calls and says, I've been to a mediator, I have an agreement, I need somebody to review it, my engagement letter is to review the agreement. I'm not negotiating any further, and I'm not taking them to court. I'm not accompanying them. Most people typically don't want to spend the money if they have an agreement and they reached it through a mediator, so the relationship is good enough, between the parties, that they may not feel so anxious appearing for that final hearing. They're probably not going to want to spend, at least a few $100s, even if you're, quick in and out, to have somebody accompany them. So and even if that were the case, if it's the final hearing, judgment enters and I'm out of the case anyway. So I really wouldn't need an LAR. Am I understanding your question though?
And I have a whole series of clients too who, they don't mind coming up with an hour of my time kind of here and there as they go through the process, but they want to kind of continue to represent themselves. So they'll meet with me, before a a court date, they'll get a phone call from opposing counsel, they'll come in for another conversation, and they kind of come in on a kind of as-needed basis for consultations and, charge them a regular kind of hour of my time, but I still kind of cover my bases, We had this conversation, we signed a limited assistance fee agreement. The purpose of the agreement, of our relationship was, for advice and consultation regarding your ongoing litigation. Of course, I'd be happy to, step in. However, this conversation doesn't create an ongoing attorney-client relationship. So even though it kind of can seem like, oh, it's just another consultation, I'll have them in, it's still you kind of reminding yourself, reminding the client, and still providing an opportunity that if the client wants to come in farther, that they can do that. If they do want you to come into a hearing, or they do want you to do more, you're leaving the door open for them, but you're still kind of managing their expectations and just kind of creating boundaries too. The clients always need the boundaries.
And keep in mind, a new rule went into effect January 1st?
Yeah.
Yeah. Are you all aware of the new rule that came out about written fee agreements? So, I can see getting a little stumbled. I mean, it doesn't apply to consultations, but I would be wary if you're going to continue on a consulting basis, an ongoing consulting basis, rather than just say an initial consultation. That could be, you want to make sure that you have a fee agreement. Now, in a case like that, I'm not sure if I would view it as, again, as an LAR. I would probably just do it as an engagement letter, explaining that I'm just consulting with them, as opposed to, a limited assistance. But my engagement letter says, and I'm not going to court. I understand that you've got a court date on, I'm not going.
Good
I
luck
say it
with
nicer,
that.
Obviously, but direct. I mean, if you decide to retain me for this next court event, for which I am not presently planning on attending, we need to fill out, sign a new engagement letter.
Yeah. Other questions?
What are the reasons you delay filing an appearance until that particular pretrial date or temporary date? I mean, it sounds like you're handling both at the same time with the withdrawal. I usually have that in talk to attorneys. It just seems like they're calling for fish. I don't know if they're going to file it. And that's not specifically LAR.
Right.
Those are usually better if you have like temporary date and know maybe they're going to be there for pretrial date. And if you have a problem sending your parents early and asking me a copy of that, if it's 2 weeks for the temporary days.
No, if I know it and I'm negotiating. I was saying that earlier that I didn't have a notice of appearance because I'm not planning on filing a notice of appearance. Sometimes I'm retained only to try and settle it or even understand. Sometimes people file pleadings that are not entirely clear, or they can't be understood by somebody because it's a modification, but they don't know what the change is. Sometimes people just file really bad pleadings. What was the change? I don't like this anymore, or it's something that's hard to understand. So it may be a matter of me calling opposing counsel, and unfortunately, it's even sometimes by attorneys who do those bad pleadings. It may be with another pro se that I'm engaging. If it's another pro se, we all know those stories, and I take even more precaution in sending a letter, I won't appear in court, etc., to the pro se person. But no, I don't have a problem. I mean, it's easy enough to do the notice of appearance. I will gladly do it if that's what they want. From one perspective, I wouldn't file by mail my notice of appearance and my notice of withdrawal in the mail. I mean, I think a clerk would receive that and say, this person has flipped their lid. That doesn't even make any sense. A notice of appearance and a notice of withdrawal. And of course, the date is different as well. So if I don't have to, I do tend to file it that very day because I tend to date it the day of the event, the notice of appearance and the notice of withdrawal. I don't know why in my head I think it's less confusing, but I would have no problem. And in those cases, my notice of withdrawal is on the top of my my folder. It's on the inside of my, it's all over the place. You know, I make extra copies because I just don't want to end up in a case that I didn't think I was going to end up in. But I think it's, you know, you might be the rare exception that I talk about of somebody saying, I'm not going to negotiate with you. Your client has pulled a lot of games on me. I'm not going to negotiate unless somehow I really believe that you have any skin in the game. Now, theoretically, as an officer of the court, you know, I'm presenting myself in a certain way, and they should accept that. And I don't think that they're doubting me, attorney Laura Flatt. I think what they are legitimately concerned about is your client's going to not follow through.
Yeah, yeah.
I think that's a great question. I am not specifically marketing LAR. I'm not entirely sure how you would do that, but you can put yourself out there to do LAR. You know, in my marketing and networking, depending on the circumstances, I'll make a point of bringing it up. I think it's a great opportunity. I think you're naturally marketing every time, you know, you meet an opposing counsel when you're doing LAR and they don't do it. I mean, I often have conversations with opposing counsel who are intrigued by the idea of doing LAR. You know, how does this happen? How do you get to do it? And, you know, because most of the time opposing counsel, even if the parties are quite contentious, hopefully you're being civil at least to each other. And so you do engage in a little conversation as you're breaking the ice. So I haven't. There is somebody, gosh, I'm embarrassed. I was on a LAR panel with her. She's in Maine. And, you know, I think Maine must have started LAR before Massachusetts. This is a while ago that I was on a panel with her, but her website really promotes LAR. So I think, I don't remember what the key terms were that would bring her up.
Yeah.
And then, of course, by putting your name into the court, I mean, that's something that you're doing as well. Do you market any differently?
Yeah, I do. And I think it's creating the value proposition. You don't want to be putting yourself out there as an attorney only for poor people. You want to create a value proposition and articulate it in a way that's going to leave you open. But I certainly have written articles in kind of local, you know, those local kind of publications, the Beacon Hill Banner and the Norwood Record, those kinds of things. Certainly promoting myself as someone who is an attorney doing limited assistance and flat rate and value billing and pay as you go, and to kind of create a value proposition and articulate it in a way that doesn't pigeonhole you, that's going to